life or another, most Americans will find themselves involved in some kind of court proceeding. Therefore, it's very important to understand what the constitutional rights are for people who are put on trial. That's what the Sixth Amendment to the United States Constitution is all about. My name is Dr. Rick Gardner from Columbus State University, and this is a Muskogee County School District podcast. Here is what the Sixth Amendment says. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Again, the main idea that the Founding Fathers had in mind here is to protect citizens against any sort of unjust or unfair governments and government officials. Persons accused of crimes, called defendants, are to receive the utmost protection of the Constitution, while the persons doing the accusing, called the plaintiffs, have the utmost responsibility for proving that the defendant is guilty. After the Salem witch trials, a saying became generally accepted regarding American justice. It is better that 100 criminals go free than that one innocent person be falsely condemned. With that in mind, the Founding Fathers wrote the Sixth Amendment, and it was written to give defendants safeguards in the event that they might be innocent. Let's look at each of the 7 parts of the Sixth Amendment. The first part is that a criminal defendant has the right to a speedy trial. This doesn't mean what it sounds like. The trial itself is not a quick and rushed procedure. The attorneys don't have to talk real fast during the trial. The word speedy refers to the amount of time between when the accusation is made and when the trial actually takes place. The Sixth Amendment states that the government prosecutor cannot recklessly delay the trial while the defendant waits in jail or in a state of suspense. The general rule is that a trial has to occur within the same year as the accusation. Now, there are exceptions for legitimate reasons, and if the defendant agrees to a delay for one reason or another, he cannot complain that his Sixth Amendment right has been violated. The second part of the Sixth Amendment is that the trial must be open to the public. The Founding Fathers were very concerned that whatever the government does should be open for anyone to see. This is designed to keep the government from committing injustices against citizens. So court proceedings are almost always public. Court records are available to be read by anyone. These days, almost all court records are being put on the internet to be accessed publicly. Yes, that may seem like an invasion of privacy, but it's based on the Sixth Amendment constitutional principle that what the government does should be open to the public. So if you're convicted of a crime, or if you get divorced, or even if you get a traffic ticket, these are court proceedings and they're constitutionally open to the public. Now, there are a handful of exceptions to the public nature of court proceedings. Juvenile courts, for example, are usually closed to the public. The court records for children are not considered something that we as a nation believe should be open for the world to see. There are some other cases where safety and security demand privacy, and in those cases, a judge may find compelling reasons to seal the court records or to close the proceeding to the public. But if there are no compelling reasons, trials must be open to the general public. As a civics teacher, I took my students to the courthouse on field trips quite often. We would sit in on criminal trials, divorces, traffic court, and civil suits all the time. Sometimes it felt weird to be walking in on what seemed to be a very personal matter, but the Sixth Amendment says that we not only had a right to be there, but that our presence there was one of the safeguards that made sure that the government was operating fairly. Now, the third part of the Sixth Amendment states that a person has the right to have the final decision about their guilt determined by an impartial jury. A jury is a collection of average citizens, usually chosen by a random drawing, and usually numbering 12. It was the strong feeling of the Founding Fathers that the people best suited to make life and death decisions in our country are common folks. People guided by common sense and people who are familiar with the circumstances of living in America. The phrase used for these people is often a jury of your peers. That is, people who come from similar walks of life. We've resisted leaving the decision in the hands of the experts or the legal scholars or even the professors. Instead, our Constitution lifts up the wisdom of the ordinary citizen using his or her common sense. The fourth part of the Sixth Amendment states that a person has the right to have the trial take place in the same region where the crime occurred. You see, just before the Constitution was written, under the British government, Americans were frequently arrested for crimes that they allegedly committed in America, but were dragged 3,000 miles across the ocean and put on trial in front of a British jury of the people who had no familiarity at all with America. The fundamental principle is that the best jury is a jury that essentially is made up of people from the neighborhood, people who understand your context and who want to be sure that justice is done because they're aware that they too could be potentially in a defendant's position someday. The fifth part of the Sixth Amendment assures a person who's been arrested that he or she has the right to know exactly what he or she is being accused of doing. The government must state in writing what the charges are against the defendant. There is a process called a writ of habeas corpus that requires the government to establish before a judge the reason for keeping a defendant locked up. If a government official does not explain the cause, the person must be set free. The principle is that the government can't just throw someone in jail without making the reason for it abundantly clear. The sixth part of the Sixth Amendment pertains to witnesses. The Founding Fathers wanted to make it perfectly clear that in the United States, no one should be accused anonymously. In other words, you can't call the police and say, "I think my neighbor's a criminal, so I want you to go arrest him. But don't tell him that it was me who called you." In order for a criminal to be prosecuted, someone has to press charges. Someone has to be the person who goes into court and points to the defendant and says, "I am accusing him of committing the crime." If no one's willing to go on record as the accuser, then the defendant cannot be prosecuted anonymously. The Sixth Amendment guarantees the defendant that he has the right to confront and question the person making the allegation. The person being accused has the right to demand that witnesses come to the court and tell what they know. In other words, if there's a person who saw the defendant 20 miles away from where the crime occurred at the time it occurred, that person is a relevant witness, and that person cannot refuse to come to court or refuse to say what they know. The process for forcing the witness to come and give their testimony is called a subpoena. The defendant may have subpoenas issued to compel witnesses to come to court so the jury may hear the whole story. The final part of the Sixth Amendment protects a defendant's right to have the assistance of a lawyer. It's important to us as Americans that when a case is being heard by a jury, that both sides are equally equipped to put their strongest evidence forward. If one side knows all the complexities of the law and the other side does not, then can a jury really be able to decide the case fairly? We feel so strongly that both sides need a fair chance that we've determined that a person who cannot afford a lawyer should be assigned one at the taxpayer's expense. In a famous case known as Miranda, the Supreme Court determined that every person accused must be made aware of their Sixth Amendment right to an attorney, and if not, their whole case might be dismissed. So there it is. That's the Sixth Amendment, and it's a very important one. Remember, many of you will find yourselves at one time of your life or another involved in a court proceeding. As such, it'll be very handy for you to be aware of the constitutional rights that are a gift to you from the Founding Fathers. My name is Dr. Rick Gardner from Columbus State University, and this has been a Muskogee County School District podcast, the Sixth Amendment.